the summer of 2008, a 2-year-old girl vanished. Her name was Kaylee Anthony. For 31 days, no one reported her missing. Her mother said she was working. She wasn't. She said a nanny had taken Kaylee. That nanny did not exist. Months later, Kaylee's remains were found less than a mile from home. Prosecutors called it murder. The defense called it tragedy and assumption. In 2011, the jury said not guilty. Tonight, we examine whether justice was served. Prosecutor, your opening statement.
Good morning. This case is about a little 2-year-old girl named Kaylee Marie Anthony, who is gone because the person who was supposed to love and protect her more than anyone in the world, her own mother, Casey Anthony, did something horrible and then lied about it for 31 days. The evidence will show you that Kaylee was last seen alive in mid-June 2008. We will prove that after that day, her mother, the defendant, didn't report her missing. Instead, she went out with her friends. She partied. She got a tattoo that said, Bella Vita, beautiful life, while her baby was dead, her body thrown away in a swamp like a piece of trash. We will show you the science, the smell of death in the trunk of her car, and the lies. Hundreds of lies to police, to her own parents, and to you if she takes that stand. The defense is going to try to confuse you, to blame everyone but the person responsible. But follow the evidence. It points to one person and one person only, Casey Anthony. She is guilty of first-degree murder.
Ladies and gentlemen, the prosecutor just told you a story. A sad one. An angry one. But stories are not proof. This case has no body evidence, no clear cause of death, and no timeline. The state cannot tell you how Kaylee died, when she died, or who caused it. That matters. You cannot guess your way to a guilty verdict. They want you to judge Casey Anthony for her behavior, for partying, for getting a tattoo. That may look bad, but looking bad is not a crime. Lying is not murder. Being a flawed person does not make you a killer. They will talk about smells, internet searches, and duct tape found months later in the woods. Even their own experts disagree. When experts disagree, that is doubt. The law says if there is reasonable doubt, you must find her not guilty. This case is full of doubt. The state is asking you to assume. The law demands proof. They don't have it.
Evidence will now be presented. Prosecution, please begin.
That's a nice story the defense just told you, but let's talk about what the facts actually show. They say there's no evidence? That's insulting to your intelligence. We have a child who was last seen alive on June 16th. We have the defendant, her mother, who waited 31 days to say a single word. Not to police, not to her own frantic parents, for a month. They want to ignore the car. We will present evidence that the trunk of Casey's car smelled of death. A human decomposition smell so strong that a detective could smell it from 50 feet away. We have forensic evidence of decomposition in that trunk, and we have Casey's own hair found in that trunk, with a telltale sign of death, dark banding, where the hair follicle died from a body decomposing right on top of it. They say we don't have a cause of death? We have duct tape found on Kaylee's little skull, 3 pieces of duct tape placed over her nose and mouth. You don't need a medical degree to understand that. Casey Anthony told lie after lie. She told police Kaylee was with a nanny that doesn't exist. She told her parents she had a job she didn't have. Why lie if you have nothing to hide?
Objection. Argumentative.
Overruled.
The evidence of her guilt is overwhelming.
Let's slow this down and stick to real proof, not drama. First, the 31 days. Waiting to report a child missing is terrible judgment, but it is not evidence of murder. The law does not say bad parenting equals homicide. You still need proof of a crime. Now the car. Smell is not science, it's opinion. The so-called death smell was never proven to be human. The FBI could not confirm human remains in that trunk. Trash, food, and time can explain that smell. The hair evidence? Even the experts admitted that dark banding is not a sure sign of death. It can happen for other reasons. Again, disagreement equals doubt. The duct tape? Found months later in the woods after animals and weather. No fingerprints, no DNA. No proof it caused death or who placed it there. And the lies? Lying shows fear and immaturity. not murder. If lying were enough, half the country would be guilty. The state still cannot tell you how Kaylee died. That alone is reasonable doubt.
They want you to ignore the smell of death? That's convenient. 3 different people, a cop, a tow yard worker, and her own mother, all said that car reeked of a dead body. That's not opinion, that's testimony. And the hair? That hair with death banding was found on a trunk liner that was thrown in the trash. If Casey was innocent, why did she dump incriminating evidence? The defense wants you to believe in coincidences. A dead child, a mother who never calls police, duct tape on the mouth, and a car that smells like a corpse. There are no coincidences here, only guilt. Find her guilty.
Objection. Argumentative.
Overruled.
Smell testimony is still opinion, not science. No lab ever proved a human body was in that trunk. Facts not proven. That hair banding is not a confirmed sign of death. Even experts disagreed. Throwing away trash is not proof of guilt. Emotional appeal. The state is stacking feelings, not facts. They still cannot prove how, when, or who caused Kaylee's death. That is reasonable doubt.
If it's just trash, explain the duct tape found wrapped around her mouth. Why would trash need 3 pieces of tape?
It was found months later, outside, after animals and weather moved things. No fingerprints, no DNA, no proof it caused death. 3 pieces of tape without proof is still not murder. It's speculation, not facts.
Speculation? A grandmother doesn't put duct tape on her grandbaby's mouth. A stranger doesn't put it on. Only a mother trying to silence her child would.
Objection. Pure assumption.
Substate.
The prosecutor is guessing motives with 0 proof. They cannot show who placed the tape, when it was placed, or that it caused death. You don't convict a mother based on what feels likely. You need facts, and they don't have them. The state keeps filling gaps with guesses. That's not proof. They still cannot tell you how Kaylee died, when she died, or who caused it. No science proves that tape killed her. No evidence ties that tape to Casey. This case asks you to assume the worst, not follow facts. And the law says assumptions are not enough. If there is doubt, and there is plenty, you must say not guilty.
Closing statements.
Ladies and gentlemen, the defense wants you to believe that everything in this case is a coincidence, that the duct tape found on Kaylee's mouth just happened to be there, that the smell of death in Casey's trunk was just trash, that the 31 days of silence was just bad judgment, that the lies about a fictional nanny were just fear. But there comes a point where coincidences stop being coincidences and become proof. The evidence all points in one direction: a mother who wanted her freedom, a child who was in the way, and a cover-up that lasted 31 days. The defense says we don't have proof. We have the trunk. We have the lies. We have the tape. Use your common sense. Find her guilty.
Ladies and gentlemen, Kaylee's death is heartbreaking. Nothing I say will change that. But sadness cannot decide this case. The state wants you to punish someone because this hurts, because it feels wrong, because you're angry, but anger is not proof. There is no cause of death. There is no clear crime scene. There is no proof that Casey Anthony killed her child. You cannot fill the gaps with fear. You cannot guess. You cannot say, I think, or it feels like. This is a mother on trial for her life. The law demands certainty, not emotion. If you have even one real doubt, and you do, you must say, not guilty.
The courtroom is now yours. Prosecution or defense? Tell us your verdict in the comments. And don't forget, this isn't the only case on trial. Check out our other AI Courtroom episodes and decide for yourself which debate was the strongest. Subscribe and join the new era of justice. Court is adjourned.
Shoe prints, exact match to rare Bruno Magli size 12 shoes OJ owned. He lied under oath, saying he never had them.